987654321. The Committee on the Judiciary, Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Without objection, the chair is recognized and authorized to declare recesses of the subcommittee at any time. I welcome everyone to today's hearing on the potential remedies for unlawful evictions in federal emergency areas. Before we continue, I'd first like to thank the committee for its indulgence in putting up with the airline's flight delays, but we made it. I'd like to remind members we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to judiciarydocs@mail.house.gov, and we will have them distributed to members and staff as quickly as we can. Finally, I ask all members and witnesses, both in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself at any time you seek recognition, and of course, those of you who are virtual can unmask yourself. For those in the room, I note, Mr. Johnson liked that one. For those in the room, I note that updated guidance from the Office of the Attending Physician provides that those who are fully vaccinated from COVID-19 do not need to wear masks or maintain social distancing. If you're not fully vaccinated, you're required to continue wearing a mask and maintaining 6 feet of social distancing. I take it Mr. Johnson has been fully vaccinated, and I welcome you to the club. I will now recognize myself for an opening statement. The purpose of today's hearing is to discuss the issue of unlawful evictions during the COVID-19 pandemic and potential legislative remedies to address such unlawful evictions during national emergencies. The COVID-19 pandemic has ravaged this country and the world, impacting people's health, jobs, and their daily activities. In the United States, millions of people have lost their jobs, experienced reduced income, and lost loved ones due to the novel coronavirus. For many of these people, the past year has been a struggle to put food on the table, pay their bills, and afford rent. These struggles have been especially pronounced in communities of color, which have been disproportionately impacted by the pandemic. Even before the pandemic began, a lack of affordable housing and evictions had been longstanding issues. They've been longstanding issues in America forever. According to 2018 statistics, nearly half of all renter households were rental cost burdened, paying more than 30% of their income towards rent. And on average, between 2000 and 2016, more than 3.6 million eviction cases were filed in the U.S. per year. Early on in the pandemic, experts warned how the loss of jobs and income due to coronavirus public health measures could lead to an eviction crisis. In response, the federal government took action. Congress passed the CARES Act, which included an eviction moratorium. After that moratorium expired in the summer of 2020, the Centers for Disease Control and Prevention issued an eviction moratorium, which has been extended several times both legislatively and administratively, and is now slated to expire at the end of the month. While these moratoria were not perfect, they offered many people a reprieve and helped them stay in their apartments and houses during a time when the best thing we could do for our health and the health of others was to stay at home. Unfortunately, since these moratoria were put in place, there have been reports across the country of landlords engaging in unlawful evictions in order to circumvent them. These so-called self-help evictions can generally be defined as actions or courses of conduct by a landlord intended to oust a tenant without the benefit of a judicial proceeding. They can take many forms, from a landlord changing the locks on an apartment, or cutting utilities, to refusing to make essential repairs, or moving a tenant's furniture and belongings out of their apartment. Tenants facing these self-help evictions often have limited avenues for recourse, especially low-income tenants who do not have the resources to afford legal representation or fight that eviction in court. These actions by unscrupulous landlords to circumvent federal moratoria, which are meant to protect public health, are appalling and merit a response. That's why I introduced H.R. 1451, the Emergency Eviction Enforcement Act of 2021, to address self-help evictions during national emergencies. This bill would provide a private right of action in federal court against landlords for tenants who were evicted without duly issued court orders. Tenants would also have a right of action when the landlord threatens, harasses, intimidates, or creates a hostile environment for the tenant or impairs the habitability of their home for the purpose of causing them to vacate the property. In addition to entitling successful plaintiffs to injunctive relief and repossession of the property, my bill would also entitle them to damages, which, in addition to repairing some of the damage done to the tenants by these unlawful evictions, would also help deter landlords from engaging in these unlawful conduct to begin with. If anything, one of the key lessons of the past year is that the government was not adequately prepared to respond to a public health crisis. As we took to respond to the issue of unlawful evictions during the pandemic, it is important that we plan for the next pandemic or other national emergency. This is why my bill would apply not just to unlawful evictions occurring during the current national public emergency, health emergency, but also in any area declared by a president as a national emergency in the future under the National Emergencies Act, Public Health Services Act, or the Robert T. Stafford Disaster Relief and Emergency Assistance Act. The loss of one's home can have a tremendous negative impact on a family, including on their safety, health, and ability to work. In the Western District of Tennessee, which includes my congressional district, we are already seeing the impact of legal evictions as the district court for the Western District of Tennessee struck down the moratorium. But even in areas where the CDC moratorium is still in effect, unlawful evictions continue with limited recourse for the tenants who experience them. We owe it to the American people who have suffered so much in the past year to take action. Our witnesses today will make clear how pervasive unlawful evictions are throughout the country during the current pandemic and the long-lasting impact these evictions can have, especially on low-income people and people of color who are disproportionately impacted by both the pandemic and the eviction crisis. There are obviously economic effects, but there are emotional, psychological, unsettling effects, and ones that could follow children and people for years and years to come being evicted from your house. I thank our witnesses for joining us today and look forward to their testimony. It is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Chairman Cohen. It will be no surprise that we have a bit of a disagreement about the subject. The Founding Fathers recognized that a right to property is a right that protects liberty itself. John Adams observed, property must be secured or liberty cannot exist. In the Fifth Amendment, the founders protected private property from government overreach, providing, quote, that no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Indeed, private property is a principle that finds its roots all the way back into our Judeo-Christian traditions, beginning in the passages in the first books of the Old Testament. Yet today, Americans' fundamental right to private property is under threat. Last summer, as rioters destroyed mom-and-pop stores in cities across America, some elected officials encouraged those individuals. For instance, Portland District Attorney Mike Schmidt dropped over 90% of riot and protest-related offenses from the unrest last year and stated, quote, sometimes it takes some property damage. He said, it takes more than just peaceful protest to get the government's attention, unquote. Here in Congress, some have referred to federal law enforcement officers who work to stop the looting and destruction as, quote, stormtroopers, and even raise money to bail out rioters. One of our colleagues has gone so far as to urge citizens to, quote, get more confrontational in the face of months of civil unrest. And now the Democratic Party has in its sights apparently federalizing landlord-tenant law, having landlords in my home state, Louisiana, be controlled by the same federal dictates as those in New York City or Los Angeles during a national emergency. The COVID-19 pandemic posed serious threats to Americans' health and economic well-being, but one-size-fits-all mandates from Washington, D.C. are not the way to address those concerns. Landlord-tenant law has long been the domain of states because it arises from each state's own common law traditions. Each state should remain free to determine those questions, like how and when a landlord can evict a tenant who poses a danger to him or the community, a tenant who has been delinquent on their rent for a certain period of time, or a tenant who has broken other terms of their lease. Most of all, the pandemic is now receding and Americans across the country are returning to their normal lives. We should be looking forward and not using a past threat to impose onerous policies for the future. The Democrats' policies are reckless in this regard. They're spending Americans' hard-earned money and causing inflation across the economy, especially on the price of household goods. Each dollar spent by ordinary families now buys less than it did just 6 months ago. Democrats keep extending enhanced unemployment benefits, incentivizing Americans not to work while millions of good-paying jobs are unfulfilled. Democrats are catering to teachers' unions, are keeping schools closed, and forcing many parents out of the workforce to stay home and care for their children. It's no wonder Americans are moving out of Democrat-run cities to safer and freer states. Democrat policies are defunding the police and catering to tone-deaf teachers' unions and closing schools and shutting down churches while tattoo parlors are able to operate down the street, ignoring homelessness and imposing ever-increasing taxes. These are all the reasons many Americans are leaving cities like San Francisco and New York City and Chicago. California, New York, New Jersey, Michigan, and Illinois, all historically Democrat-run, lost a combined 4 million residents since 2010. And that census data accounts for this exodus before the pandemic, further exposed these cities for being so poorly run. How about Democrats do what's right for the American people? Why don't we open the schools? Why don't we tamp down on unnecessary spending and get Americans back to work? These ill-advised policies are weighing down an American economy trying to rebound from the global pandemic. It is time for America to get back to work. For those who are still unable to return, there are ample federal and state resources to assist in housing costs. No paying law-abiding tenant should ever be thrown out without legal recourse. The contract between a tenant and a landowner must be honored, and state courts should be quick to reconcile any breaches of these contracts. Our responsibility in Congress is not to hand out free housing. It is to protect private property rights of every single American. This fundamental principle is a cornerstone of our country, and it has served as the bedrock of fostering the greatest economy the world has ever seen. I hope that this hearing today makes that clear. I thank the chair, and I yield back.
Thank you, Mr. Johnson. We welcome our witnesses and thank them for participating in today's hearing. I'll now introduce each of the witnesses, and after each introduction, we'll recognize that witness for his or her oral testimony. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, for our witnesses testifying in person, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For our witnesses testifying remotely, there's a timer in the Zoom view that should be visible at the bottom of your screen. Before proceeding with testimony, I'd like to remind all of our witnesses that you have a legal obligation to provide truthful testimony and answers to this subcommittee, and that any false statement you make today may subject you to prosecution under Section 1001 of Title 18 of the United States Code. Our first witness is Hillary Shelton. Mr. Shelton is director of the NAACP's Washington Bureau and its senior vice president for advocacy and policy. Mr. Shelton is responsible for advocating the federal public policy issue agenda of the oldest, largest, and most widely recognized civil rights organization in the United States. Mr. Shelton's government affairs portfolio includes crucial issues such as affirmative action, equal employment protection, access to quality education, stopping gun violence, ending racial profiling, abolition of the death penalty, access to comprehensive health care, voter rights protection, federal sentencing reform, and a host of civil rights enforcement, expansion, and protection issues. He's very busy. Mr. Shelton holds degrees in political science from Howard University, in communications from the University of Missouri in St. Louis, and legal studies from Northeastern University. Mr. Shelton, you are recognized for 5 minutes.
Thank you very much, and good afternoon. I want to say good afternoon to Chairman Cohen, Ranking Member Johnson, and esteemed members of the subcommittee. I'd also like to thank you for inviting me here today to discuss a pressing topic as we fight against the unlawful evictions of tenants taking place even during the middle of the national health emergency. This issue is especially concerning to the NAACP. As you mentioned, the NAACP is an over 100-year-old organization that is focused on these issues as part of a movement for decades upon decades. As you're aware, the COVID-19 pandemic and the economic crisis that followed had a direct and negative impact on many Americans in several aspects of their lives, whether it be on their physical, mental health, well-being, education, opportunities, or financial situations. For those already in economic distress, those living paycheck to paycheck, struggling to afford rent and pay bills, the pandemic exacerbated an already dire situation. The severe lack of affordable housing in this country and the high rate of evictions among people of color long preceded the COVID-19 pandemic. But this crisis has brought this issue to the forefront of the national conscience and shined a light on the pain many individuals and families are experiencing right now and have experienced for decades. Now, I don't want to get into a debate over whose pain hurts more. However, During all of this, a common theme that we see in this country has been made evident once again. Whenever America goes through a storm, African Americans and communities of color are hit the hardest. As the country locked down and economic activity slowed, millions lost their jobs and their only means to pay for the basics like housing and food. So as we saw hospitals fill up with sick Americans, we also saw and still see today thousands upon thousands of individuals and families forced out of their homes because they can no longer pay rent. In light of the massive wave of evictions and the potential for millions more due to the course of the pandemic and the slow economic recovery, the federal government stepped up and implemented a moratorium on evictions to provide much needed temporary relief for families in distress. Though this moratorium was a necessary step to cushion the cushioning blow of the crucial blow of the American families that can only be looked at as a Band-Aid solution at best. Despite its good, this wall of protection is slowly crumbling as a federal district court in Memphis, Tennessee, recently ruled in favor of the landlords and allowed eviction to proceed. These self-help evictions were landlords taking it upon themselves and circumventing eviction moratoriums to remove tenants from their dwellings, are displacing already vulnerable families and once again, disproportionately hurting people of color throughout the country. Even as this country begins to get back onto its feet, we see the economy start to roar again. Millions of families are still in dire financial circumstances and need the time and support to recover from the hardship of the past year. As long as these moratoriums are in place, tenants should remain temporarily protected from the fear of becoming homeless and thrown even more deeply into the spiral of poverty. This is why Congress must fight to ensure that eviction moratoriums put in place due to a public health emergency are not being ignored by landlords who are eager to get back to business as usual. And that's why I'm here today, to show our strong support and advocate wholeheartedly for HR 1451, the Emergency Eviction Enforcement Act of 2021. This bill will go a long way towards providing tenants the protections and level playing field that they deserve when they are in dispute with their landlords. Landlords will no longer be able to ignore eviction moratoriums or try to create hostile environments to push tenants off of their property. To understand the potential impact of this bill, you only need to look at the crisis taking place in Congressman Cohen's home district in Memphis, Tennessee. Though a federal order will protect Americans from evictions until July, at least in word, the reality on the ground right now is much different since a federal court essentially invalidated the moratorium on evictions. As local and national restrictions on evictions begin to ease, thousands will be forced from their homes and into distress, especially African-American renters, whom we know are more likely to face eviction compared to their white counterparts. So with that, let me close for now, but look forward to your questions. The challenge is here for us in recognizing that different things hit different communities in different ways. And even as we go to look to find new jobs and new opportunities, African Americans have found the time between leaving one job and going to another is usually twice or longer than it is for most other Americans. Listen, I thank you very much and look forward to your questions.
Thank you, Mr. Shelton. The NAACP has often been known as the conscience of the country, and you are the voice of that conscience. Thank you so much. Our next witness is Cindy Cole Ettengoff. Ms. Ettengoff is the CEO and General Counsel for Memphis Area Legal Services Incorporated. She's involved in Tennessee, in this Tennessee statewide task force focusing on housing, unemployment, and access to justice. Prior to joining legal services, she practiced in the areas of labor and employment law, representing employers, employees, and unions in OSHA, Wage and Hour, National Labor Relations Act, Title VII, FMLA, ADA, EA, and other employment law matters. Ms. Ettengoff is a commissioner on the Tennessee Alternative Dispute Resolution Commission, past chair of the Tennessee Bar Association Dispute Resolution Section, current president of the Tennessee Association of Professional Mediators, and is the representative of the Heralded Memphis Area Legal Services, founded by Mike Cody and others. Ms. Ettengoff earned her JD degree from the University of Memphis, Cecil C. Humphrey School of Law, and has an MS in cell biology and BS in microbiology from the University of Memphis. Ms. Ettengoff, you are recognized for 5 minutes.
Thank you. I certainly appreciate the opportunity to speak with you today. And of course, you mentioned Memphis Area Legal Services, MALS. To those of us, it's an LSC-funded nonprofit law firm that provides pro bono legal services primarily for individuals with low income or no income. MALS also offers services through the Memphis Fair Housing Center program, which we administer. And that program serves to increase home ownership opportunities, promote decent, affordable housing, and ensure equal opportunity in housing. All of that to say, MALS has a great deal of experience in the area of housing, particularly when it comes to lawful and unlawful evictions. Now, as Mr. Shelton mentioned, while COVID-19 was stressful for everyone, it was and still is a nightmare for poor people. It has been an even greater nightmare for poor people of color. You know, it's been said that when America catches a cold, Black America catches pneumonia. And that has certainly been the experience of many of our clients. As a result of COVID, many of our clients lost jobs. Many, if not most of our clients, live paycheck to paycheck. As a result, when job loss occurred, they had no reserves that would enable them to continue to pay rent. Now, while some employees are being asked to return to work, not all are, and many of them are being asked to return to the same job for less pay. So the underlying economic problems that exacerbated the COVID-generated eviction emergency continue. We are aware, of course, that the CARES Act eviction moratorium and the CDC eviction moratoria were intended to prevent the eviction of citizens who were unable to pay their rent due to COVID-19. Despite those moratoria, for the last 14 months, MALS has continued to receive calls from individuals who are being threatened with unlawful eviction or who had actually already been unlawfully evicted. Existing laws provide that if an eviction is unlawful, the tenant has the right to bring a legal action. But the right to bring an action is not at all the same thing as the ability to bring a legal action. Landlords well know that if a tenant did not have money to pay rent, they are unlikely to have funds to pay for legal representation. Those tenants frequently turn to MALS and other legal aid organizations. In fact, during the moratorium, MALS received approximately 1,200 requests for legal assistance that involved evictions. And MALS takes as many of those cases as it can, certainly. Of course, with the result of high demand and staffing limits, there are times when clients must be turned away. National statistics reflect that 91% of landlords are represented by counsel, while less than 4% of tenants are represented by counsel. Clearly, there's an imbalance of access to justice. So that leaves us with the question of how do we level the playing field to prevent unlawful evictions during national emergencies, such as the COVID pandemic? What might be the best remedy for unlawful evictions? In my opinion, the best remedy for unlawful evictions is for the evictions to never occur. And that requires deterrence. In order to deter unlawful evictions, it's my belief that the penalty for engaging in the unlawful conduct has to exceed the monetary benefits of the conduct. And that is what HR Bill 1451 may well do. It may act as a deterrent and may thereby prevent unlawful evictions. Unlawful evictions cause so much harm to our communities and to the future of our communities, to our children. In order to stop unlawful evictions, particularly during national emergencies, a message must be sent to those landlords who understand and exploit the imbalance of power between those who can afford to fight against injustice and tenants who cannot. The threat of treble damages is certainly one of those messages that can be sent, and it's a very clear message. You know, I assure you that there's a need for such deterrence, and I appreciate the opportunity to speak with you here today. I am happy to answer any questions. I look forward to them here shortly.
Thank you, Ms. Eddinghoff, and go Tigers. Our third witness is Joel Griffith. Mr. Griffith is a research fellow at the Institute for Economic Freedom and Opportunity of the Heritage Foundation. Previously, he worked as researcher for former member of the Wall Street Journal editorial board and was deputy research director of the National Association of Counties, also known as NACO. He also was director of the Center for State Fiscal Reform at the American Legislative Exchange Council, also known as ALEC. Mr. Griffith received his JD from Chapman University, Daley Fowler School of Law with a dual emphasis in alternative dispute resolution and federal income taxation. He received a BS from Pensacola Christian College. Mr. Griffith, you're recognized for 5 minutes.
Thank you, Chair Cohen, Vice Chair Ross, Ranking Member Johnson, and other members of the committee for the opportunity to testify today. My name is Joe Griffith, and I'm a research fellow at the Heritage Foundation. This testimony will focus on eviction moratoria, along with a proposed private cause of action in federal courts for wrongful eviction. The eviction moratoria of the past year unfairly burden property owners with the cost of societal shutdowns. They create unintended consequences, and they implicate serious legal and constitutional concerns. Last year, for the first time in our nation's history, state and local governments intentionally suppressed and criminalized entire swaths of economic activity. The eviction moratoria, whether implemented by federal, state, or local governments, forced property owners to subsidize these destructive shutdowns and enabled politicians to shirk responsibility. Keep in mind, by December of 2020, the 10 states with the fewest economic restrictions in place averaged far lower unemployment than those states with draconian restrictions. Economic conditions varied wildly state to state. Just compare Florida to New York. Property owners in those states which are shut down should not be forced to subsidize those state and local politicians that are choosing to shutter these businesses, close schools, and ruin livelihoods. Regardless of the intended beneficiaries of moratoria, these eviction moratoria allowed many who were not even impacted financially to live rent-free throughout the past year. Data from the National Multifamily Housing Council showed only a minimal increase of 2.2 percentage points in late rental payments in July 2020 versus July of 2019. But despite the relatively small increase in the number of people that were making their rental payments late, many local governments chose to preemptively issue moratoria on evictions throughout the entire pandemic. The near complete eradication of evictions, coinciding with only a slight rise in those making delinquent rent payments, strongly suggests that this moratoria allowed many who were neither impacted by COVID-19 nor experiencing financial hardship to live rent-free with no immediate personal consequences. These eviction moratoria produce harmful ripple effects. Landlords may need to increase rents to mitigate the heightened risk of future moratoria. Prospective renters may find themselves subject to increased security deposits and tighter credit checks. And ultimately, fewer affordable housing units might be constructed. Quality of life for other tenants is impacted as well, as landlords are unable to evict many tenants for disorderly conduct, illegal drug use, and criminal activity. Moratoria also invoke serious constitutional and legal concerns. They often violate the takings clause of the 5th and the 14th Amendments, along with the contract clause. Without a doubt, the CDC's ban on eviction proceedings was unlawful because it exceeded its congressional mandate. The executive order last year prohibiting landlords from using the court system to evict tenants until the end of the year was predicated on the Public Health Services Act, which authorizes regulations necessary to prevent the introduction, transmission, or spread of communicable diseases. But examples of congressionally authorized actions that were actually listed in the act come nowhere close to including eviction moratoria. Even the order itself shows that this ban was meant as an economic relief measure, not a tool to protect the public from the spread of disease. In short, both the CDC action itself, the eviction moratorium, and the intent to counter the economic impact rather than the health impact of COVID-19 violated the express will of Congress. But even if Congress had authorized the CDC to enact an eviction moratorium, such authorization itself would have been unconstitutional. Congress can only delegate to the executive branch the powers granted to it by the Constitution. And the Commerce Clause, upon which the CDC powers are based, does not provide a basis for Congress to prohibit citizens from seeking legal resource in state courts for enforcement of contract provisions. All regulations enacted under the Commerce Clause require that the regulation itself must be necessary and proper for carrying into execution the powers granted to it by Congress. Denying landlords access to state courts to enforce eviction law is not a proper use of federal government power, even if the eviction process itself were economic in nature. Banning access to state courts, forbidding a state court from exercising its lawful jurisdiction is an abuse of federal power. In fact, such a ban on accessing courts is itself a violation of the First Amendment of our Constitution, which guarantees that we have the right to petition the government for redress of grievances, and this includes the right to request the court to issue an order for eviction. Well, thank you again for inviting me today, and I look forward to your questions.
Thank you, Mr. Griffith. Our final witness is Katie Ramsey Mason. Ms. Mason is an assistant professor of law and director of the Medical Legal Partnership Clinic at the University of Memphis Cecil C. Humphreys School of Law, from which I received my degree as well. Prior to joining the Memphis Law faculty in 2018, she was a visiting associate professor of clinical law and Friedman Fellow at the George Washington University Law School. From 2011 to 2015, she was an Equal Justice Works AmeriCorps Legal Fellow and housing attorney at Lenox Hill Neighborhood House in New York City, where she represented low-income tenants and families in eviction cases and other housing-related matters. Her scholarship focused on landlord-tenant law, the eviction court process, poverty law. Her recent work has appeared in the UCLA Law Review and the University of St. Thomas Journal of Law and Public Policy. She received her JD and MA in Latin American Studies from the University of Wisconsin-Madison and her BA from Middlebury College. Professor Ramsey Mason, you're recognized for 5 minutes.
Thank you. Good afternoon. I thank Chairman Cohen and Ranking Member Johnson and the members of the committee for inviting me to speak this afternoon. My name is Katie Ramsey Mason. I am an assistant professor of law and director of the Medical Legal Partnership at the clinic at the University of Memphis Cecil C. Humphreys School of Law. Go Tigers. I have represented low-income tenants facing eviction in Wisconsin, New York, and Tennessee. And as Chairman Cohen mentioned, my scholarship focuses on landlord-tenant law, the eviction court process, and poverty law. Since the COVID-19 pandemic began in March of 2020, millions of Americans, many of them low-income people of color, have been put at risk of eviction due to non-payment of rent as a result of the devastating financial impacts of the pandemic. Recent estimates suggest that around 11 million Americans are behind on rental payments, despite millions of dollars of federal funding that has been allocated through the pandemic stimulus bills. Early on in this crisis, government at all levels, local, state, and federal, recognized the severe risk of spreading COVID-19 that were associated with housing displacement and imposed various restrictions and moratoria on eviction. Unfortunately, illegal evictions, where landlords take the law into their own hands to drive out tenants from rental properties, are an ongoing problem. The issue is particularly serious during a time of national emergency like the COVID-19 pandemic, when displaced and homeless people are especially vulnerable to contracting and spreading the virus. It is critical that Congress act to address this problem, and proposed Bill H.R. 1451 will provide important protections for tenants at risk of being illegally evicted. Even though self-help evictions are illegal in every state, they nonetheless continue to happen with regularity. All states have a judicial process in place to govern evictions, but research from leading eviction scholar Matthew Desmond of Princeton suggests that nearly half of all evictions take place informally outside of the judicial system. Many of these informal evictions fall into the illegal self-help category. During the pandemic, the problem of illegal evictions has been exacerbated. In June 2020, 91% of legal aid attorneys across the country who were surveyed by the National Housing Law Project reported illegal evictions in their areas. While most states do allow tenants to sue landlords who have engaged in illegal self-help, proposed Bill H.R. 1451 is not duplicative of existing remedies. It would be an important addition to tenant protection measures that have not always allowed for effective relief. First, H.R. 1451 is intended to apply only during times of federally declared emergencies, such as the COVID pandemic. The definition of illegal self-help and the available remedies can vary significantly from state to state, and this bill provides uniformity and clarity as to what constitutes illegal behavior and what relief is available to people who are affected. Second, HR 1451 provides multiple mechanisms for enforcement, which is an important improvement over previous federal tenant protection efforts, including the CARES Act eviction moratorium and the CDC's order that has halted many residential evictions. HR 1451 provides both a private right of action for tenants who have been illegally evicted during a national emergency, and also allows the United States Attorney General to bring causes of action against violators of the law. This will go far towards making the law effective in its purpose. Compliance will be encouraged, bad actors will be deterred, and people who are evicted during emergency times will have a better chance of obtaining the relief that they are entitled to. Finally, congressional action on this issue is necessary in order to provide effective protection to vulnerable tenants during times of crisis. The most comprehensive set of protections for tenants during the current pandemic came not from Congress, but from the CDC. And that order has been vulnerable to legal challenges, something we have felt acutely here in Memphis. We are currently the only jurisdiction in the country where the CDC's order is unenforceable, and our low-income tenants have paid the price. Congressional action, as opposed to agency action, would have forestalled many of the claims being brought in the federal lawsuits against the CDC's order and provided stability and clarity to the tenants it is intended to protect. I thank you for your time this afternoon, and I look forward to your questions.
Thank you, Professor. We will now proceed to the 5-minute rule with questions, and I'll recognize myself for 5 minutes. Mr. Shelton, Mr. Johnson rightfully said in his opening statement that traditionally landlord-tenant law is determined by the states. The federal government, of course, has gotten into certain issues in the Federal Housing Act to address discrimination in housing. Why is it that during a national pandemic, as this bill attempts to do, that the federal government should be the appropriate sponsor of legislation and passer of legislation to protect people who are affected by a national emergency, and particularly African Americans who are, as I think somebody said, the cold and the flu, or the pneumonia, the folks who get the pneumonia?
No, thank you very much. There are a number of reasons. First, of course, when we think about a pandemic, it's not something that just impacts people in a local jurisdiction or a particular state. We're talking about something that has impacted people throughout the United States and outside the United States, throughout the world as well. As such, we look forward to our federal government being able to address issues and challenges along these lines, and that's why the Center for Disease Control is given the kind of power and authority it is, as we see how when a disease like this pandemic hits, it doesn't limit itself to a certain city. It doesn't limit itself to state lines, as most of our federal laws are crafted to address. It expands itself across state lines, other lines, and so forth to create the kind of damage we're seeing. As you know, even as our president is visiting other countries in Europe, he recognizes that the impact of the coronavirus is something that's hitting in very different ways. The discussions going on in Britain and otherwise are showing new strains that are creating a new set of problems, again, that are much broader and more severe than something in a local community or neighborhood.
Thank you, Mr. Shelton. Ms. Eddinghoff, who gave me the cold and pneumonia story, you've worked with people in the vineyards and worked there with people on the ground in Memphis and concerning evictions. What impacts can evictions have on tenants beyond just the loss of their current housing, and what is the loss of their current housing due to a person's self-esteem, children's self-esteem, and possibly even during a pandemic, more importantly during a pandemic, can it cause them to be more vulnerable to disease and spreaders?
Thank you, Mr. Cohen. Absolutely. Loss of housing means you're additionally set back. Not only are you in a situation where you were unable to pay your housing, your rental fee, but you had at least your belongings. Your child had their lovey, your child had their school books, your child had their clothes or their shoes. And to come home and find those belongings either sitting at the street or more likely gone, taken, can be an absolute trauma for a child. And then the next situation is, where is the child and the parent going to live? Are they going to have to split up children? Are they going to have to live in the car? Are they going to move from spot to spot? It affects children's education because even though, and I know that there's a bill that prohibits it, in Tennessee, we're still having a little difficulty with the notion that you do not have to have a permanent address to register for school. We're still kind of fighting that one on some days, and I'm sure that's true in other places as well. So what that means is children are missing school. They're missing school because they don't have their school books, or they don't have their clothes, or they didn't sleep the night before because they were afraid to go to sleep. And so as a result, you've got sort of an educational background setback. But in addition, wherever those children may land may or may not be safe. There may be violence, there may be health issues. So for those reasons, it's very, very much more than just losing the apartment that you were living in.
Thank you, thank you. Ms. Ramsey Mason, tell us specifically why you think Congress needs to act to address unlawful evictions during national emergencies, why it's distinguished from the traditional rule of law, which is that it's up to the states, but then why in national emergencies should we look outside of the tradition of states, and how are tenants experiencing unlawful evictions, how would they benefit from access to the federal courts?
Thank you, Mr. Cohen. I'll try to keep my answer brief. Congress should act because Congress has acted in many other capacities during the pandemic to address some of the worst impacts that the country has seen as a whole in the last 14 months. And evictions are no different. Evictions, in fact, as Ms. Eddinghoff pointed out, have consequences that go far beyond just the legal process and can impact people for years to come. And it is entirely appropriate for Congress to act in this situation in the same way that Congress has mandated mask requirements, in the same way that Congress has provided financial relief to businesses, to people facing unemployment, to people at risk of not being able to pay their mortgages. Tenants should be treated the same way. And as I pointed out in my testimony, the fact that Congress did not act with regard to an eviction moratorium after the CARES Act moratorium expired has been to the detriment of low-income tenants.
Thank you very much. My time has expired, and I now recognize Mr. Johnson for 5 minutes.
Thank you, Mr. Chairman. Mr. Griffith, thanks for being here in person. Appreciate you making the trip all the way from Miami. I think you get the credit for coming the furthest. There's an inclination right now amongst many of our Democrat colleagues in Congress to federalize everything, not just housing with legislation like H.R. 1451, but we see it with voting and policing and many other issues. But let's talk about housing. Can you discuss the importance of housing law remaining at the state and local levels rather than a federal one-size-fits-all issue? I know you talked about it a little bit in your opening, but maybe elaborate a little bit more. Why is it better, in your view, for eviction policies to be decided on the local level?
And then thank you for your question. Well, at its very basic level, Congress, anytime you enact legislation, need to ask, is this constitutionally authorized? And at its very basic level, as we discussed earlier, this is not a proper exercise of federal power because the federal government does not have a role in determining what state law is on local housing policy. But whether or not it's a proper use of government power, we can talk about the practical application of that. So even if it were constitutional for Congress to be involved, when we're talking about housing policy, it's best for it to be decided at the local level because it's the best way in which to actually hold local political leaders accountable for the decisions they make. So for instance, if the eviction law does not reasonably protect tenants, then the general citizenry can actually lobby their local politicians to change the law, to make it more difficult to evict, to change the law. And when it comes to a situation like we saw the past year, where we did see so many people in dire economic straits, oftentimes not because of the pandemic itself, but because of the shutdowns itself, it actually allows people to hold those politicians accountable, because if you're feeling the impact of the economic strain that's caused by a shutdown, then you're able to go directly to those political leaders and request that things be changed. When you federalize this, you diminish that accountability and eliminate that responsibility that local politicians should have.
That's a great summary. Let me ask you too, we're also worried about overreach in legislation like this. So what could an effect of HR 1451 be in terms of, let's just say by way of example, Biden administration declares some sort of non-crisis a national emergency. Let's say if this bill were to become law, could President Biden, for example, declare climate change a public health emergency and then therefore effectively prevent landlords from evicting non-paying tenants from their property?
That could be a very valid concern. If you look at the manner in which this emergency, the National Emergency Declaration is put into effect, it was very vague, just the enactment itself. So if we can do that for this purpose of declaring, saying there's a pandemic and putting a national emergency in place to take all of these economic actions, the precedent would indeed be set to have the executive branch trump the legislative branch and begin enacting regulations under the guise of such an emergency. And that's exactly what we saw happen over the past year with the CDC guidelines, putting in place economic restrictions that had nothing to actually do with the health crisis, but were in effect trying to curry political favor.
And if we open that Pandora's box, you mentioned briefly in your opening, the effect that might have on landlords, especially mom and pop landlords, what might they do in anticipation of any future moratorium?
Well, if the federal government has the ability to bring a cause of action against these private landlords, that in many instances will quell their ability to actually move through and protecting their private property rights. Because even if they're in the right, when you as a private landlord, especially a mom and pop landlord, are up against the power and the funding of the federal government, the attorney's fees themselves could put you out of business, and that would be a danger.
And so, because I've talked to landlords in my district back home who are deeply concerned about this, and their own families were affected because their income levels were shut off, and so their own families are going hungry at the same time that all these other crises are going on. And so the question is, wouldn't some people, mom and pops in particular, just get out of the business, stop offering these places for rent, especially for low-income housing units? And then also, wouldn't those who are still in it raise the rents because they don't have to cover the risk, right?
Yeah, if you're a smaller real estate investor with several properties that you've accumulated in order to prepare for retirement, for instance, the risk that just one of, say, 3 of those units might end up in an extended case of somebody unlawfully possessing that property, that could put you out of business. Like if you're a larger management company with hundreds of properties, you can spread that risk across. And this will, because of that, threaten to further concentrate this ownership in the hands of these larger management companies to the detriment of those that are looking to have a secure retirement by responsibly acting throughout their careers and purchasing 2 or 3 of these units to help them through retirement.
And also reduce the availability of low-income housing. I yield back. I'm out of time. Thank you.
Thank you, Mr. Johnson. And I know you, like me, are available to constituents at all moments of the day, and it would take many, many public servants to equal your efforts. Ms. Ross, you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to all the witnesses for joining us today. I just want to remind my colleagues that this hearing is on self-help evictions that are illegal under the law, and that we've heard testimony about these types of evictions that have happened both before the pandemic and during the pandemic and are likely to happen after the pandemic. And as we're talking about the pandemic right now, we know that millions of Americans have struggled with homelessness during the pandemic, and millions more are at risk of eviction when the federal and state eviction moratoria expire. People who are chronically homeless and housing insecure are at substantially higher risk of poor health, as a lack of stable housing can result in disruptions to employment, social networks, education, and the receipt of social services benefits. In short, the pandemic exacerbated issues that already were occurring. Despite local, state, and federal eviction moratoria, some landlords have engaged in these self-help evictions nonetheless. In my state of North Carolina, nearly 71,000 1,000 evictions were filed between March 2020 and February 2021. A constituent from my district lost her job during the pandemic, and she and her baby girl were evicted from their home just before Christmas because they were $380 short on rent. They didn't know where to go, and they didn't know about the eviction moratorium. Another constituent and her 2 children were evicted from their home despite being up to date on rent and providing the landlord with a CDC declaration form temporarily halting residential evictions. However, their lease was up and their landlord refused to offer renewal. This is a reality that Americans across the country are facing, and as I said, were facing before the pandemic. My first question is for Professor Ramsey Mason. Despite being illegal in all 50 states, self-help evictions persist. Can you tell us why?
Thank you, Representative Ross. I think the short answer is because it's easier and because there is not, in many states, appropriate deterrent for landlords who seek to engage in self-help. Self-help can take many forms, as HR 1451 contemplates. It can be something as extreme as a landlord hiring a team of private security guards, showing up at a tenant's home and forcibly removing the tenant and his or her belongings from the property. It can include changing the locks while the tenant is away from home, at the grocery store, at work, picking up kids from daycare, whatever the case may be. It can also include things like calling the utility company and asking for the electricity and the gas and the water to be shut off, or simply threatening a tenant to the point that they actually choose to leave the property because they feel unsafe. All of those are situations that we hear about, that we, as you pointed out, have heard about prior to the pandemic, during the pandemic, and unfortunately, I'm sure will continue to happen as the pandemic ends. While every state does allow tenants who have been illegally evicted to sue their landlord proactively to claim damages, on a practical standpoint, for many tenants, that's simply not possible. I mean, tenants are experiencing a number of crises in the aftermath of an eviction, and going to court or finding a lawyer, going to court, filing a lawsuit is oftentimes—
I'm going to have to stop you there because you're leading into my next question, which is for both you and Ms. Eddinghoff, and I'd like Ms. Eddinghoff to go first with whatever time I have remaining. Is part of this problem due to the fact that legal services aid has been cut so much and there's a reluctance to fund legal services attorneys?
Well, it certainly doesn't help things, let's put it that way. I mean, I think I mentioned that the demands far exceed what we have in the way of staffing. So that is certainly true from that perspective. And I think that as Professor Ramsey Mason was about to say, I believe that because we cannot train people really well enough to represent themselves. They don't have the ability to go down to general sessions, and they don't know the rules of evidence, and they're merely in a position where they're at someone's mercy, the landlord's mercy, unless legal services can assist them, because they're not going to be in a position where they can use what little money they've got that has to go for food or new housing to divert that money towards paid legal services.
Oh, the chairman has told me that that we can also have Ms. Mason respond.
Thank you. I am not familiar with the intricacies of legal services funding. However, I do know that having attorneys for tenants is an incredibly important aspect to preventing illegal eviction. Because if tenants are represented and are able to successfully bring claims in court, it will act as a deterrent to future bad actors. And it will also empower other tenants to assert claims that are valid in that situation.
Thank you, Mr. Chairman. I yield back.
Thank you. There is help on the way. We have a letter urging more funding for legal services. In the past, I was joined by Mr. Kennedy from Massachusetts. And this year's Mr. Fitzpatrick, Mr. Upton, Mr. Emmer, Ms. Dingle and Ms. Scanlon has been phenomenal, all as co-leads on the letter, and everybody's welcome. So hopefully that will happen. Who's next? Ms. Fishbach, you're on the video, I guess. There you are. Yep. You're recognized for 5 minutes. Thank you. And I have no jokes.
Thank you very much.
I have no jokes for today.
Oh, no jokes? Okay.
No jokes.
Well, I appreciate that. I am just very concerned. I obviously represent a very rural district, and I'm very concerned about the effect of this on what is a tight housing market. And so I'm wondering, Mr. Griffith, if you could, I know you talked a little bit about it with Mr. Johnson, but maybe you could expand a little bit of the effects on those small landlords. But in addition to that, maybe expanding into what it's going to do to the availability. You know, we're looking at a tight market in rural Minnesota, and I'm wondering if you have any thoughts on how it would affect this legislation would affect the availability.
Yeah, thank you, Congresswoman. Well, if we think about what actually happened this past year, for the first time in our nation's history, we actually criminalized landlords, property owners who wanted to simply avail themselves of legal protections. And this was a complete violation of that First Amendment guaranteed right to access the courts to enforce basic contract law. And the executive branch went a step beyond and actually criminalized any state court that would choose to actually enforce their own laws. This has not happened before in the history of the United States. This should be troubling to anyone who cares about the rule of law. And if you're a landlord, especially a small landlord, now you have to go into every contractual arrangement with a new tenant with the understanding that for a future national emergency, that the executive branch may put a moratorium on your ability to actually take hold of your constitutional right to enforce the contract that you've made with someone else. That is going to cause, I think, severe reluctance on the part of landlords. And this will impact affordable housing on top of it. But I think the primary concern here should be the assault that we saw on the basic rule of law and basic private property rights.
And thank you, Mr. Griffith. I appreciate that. And I will just express, I have real concerns because as I've traveled across my district, the one thing that people are talking about is there's just a huge need for more housing. And when we have landlords who are willing to do that and put their money on the line in order to provide rental housing for folks, we are just causing them more headache. And I think that it will, I think Mr. Griffith is right. It really disincentivize people from entering that market. And that's all I have, and I will yield back, Mr. Chair.
Thank you, Ms. Fishbach. You have not been affected by the congressional drug of taking every minute that you have to talk. You limit yourself to what's relevant. Thank you. Who's next? Mr. Raskin, you're recognized for 5 minutes.
Chairman, thank you much. I'm wondering whether landlords that are engaged in these vigilante evictions outside of the law are just doing it unilaterally on their own, or are there law firms or businesses that have organized to encourage them to do this, or to be there to manipulate the process? I don't, Ms. Mason or Ms. Engoff.
I can address that slightly. There is a group called Get 'em Out that pretty much perpetually pushes the notion of removing tenants, and that's how they make their money. That's what they're interested in. In addition, at least locally for us, there's been one law firm with one particular attorney that I can't say definitively that he has pushed the landlords to do it, but he has certainly not discouraged them in any way. Even on cases where there should have been some forbearance, he's been unwilling to reason it at times. And of course, that's the nature, I guess, of his business, and that's how he earns his livelihood. However, all attorneys represent the notion that you have the ability to communicate with your client and that you can attempt to direct your client in the direction that might be better for them in a broader sense. And that does not appear to have been done in all cases. So certainly there has been some indulgence of the notion of going ahead and sort of engaging in conduct that borders on unlawful or truly is unlawful.
Ms. Mason, did you have anything to add to that?
I think Ms. Eddinghoff is in a better position than I am to have the bird's eye view of to answer your question, but it certainly is an issue where, you know, there are many attorneys who are responsible and try to discourage their clients from engaging in illegal behavior. But again, you know, the fact that it's so difficult for tenants to actually push back when this happens, you know, many times we see stories in the media are the way that tenants get traction on these situations. And that simply should not be the case. They should be able to effectively access the courts.
Thanks. Mr. Shelton, let me ask you, it seems like we've got kind of a practical problem out there because I remember, you know, in the thick of the crisis when people were being thrown out of work and everything looked kind of hopeless, landlords and tenants got together really to push for aid to the tenants so that they would be able to get aid filtered through the states and the counties down to them, and then they would be able to pay for the rent. And so part of what we might be seeing is just the effect of that process not closing the loop. I mean, I just asked my staff to get me some stats on this, and there's more than $30 million that's been left undistributed in the largest county in my district, in Montgomery County. That's money that has not gone to tenants for the purposes of paying their rent. And so many people are unemployed and broke and so on. So what can we do structurally to just deal with this problem and get people the resources they need so we don't end up with this hand-to-hand combat in court or outside of it?
I'd be in strong agreement with it going in that direction. And that is to say, as we looked at what's happened across the country, some of the solutions that came to mind is things like a modification of Section 8 type program landlords, as well as we do to others. Making sure that people have a place to stay and we don't find individuals and families homeless is crucial. And we've seen what happens when we don't. Many of us still remember what happened with the economic downturn and the provisions we worked so hard together to put in place with the Dodd-Frank Wall Street Reform Bill to fix many of these problems as well. As we're looking at issues along these lines, we know what happens. As a matter of fact, the economic downturn of 2008 was not that long ago. And we learned some solutions from that as well. All of that to say is that we need to make sure that it's seen that there are many families that also do make their living owning small tenements. You know, 1, 2, 3, 4 family apartment building. My parents were very much within that category as well. But they also worked very hard to make sure that people could stay. And that should be the struggle here as well. When a pandemic happens, it crosses many governmental lines. When issues like this happen, it means that as we're bringing solution, we have to pull from many governmental pots to provide some solution.
I appreciate that. I yield back to you, Mr. Chairman.
Thank you, Professor Raskin. Ms. Jackson-Lee? No? Sorry, my mistake. Mr. Johnson from the great state of Georgia.
Thank you, Mr. Chairman, for holding this hearing. Mr. Griffith, you've spoken with great indignation in your voice and in your manner as you've testified passionately about how eviction moratoria has hurt landlord property owners. Are you familiar with the fact that the CARES Act signed into law by President Trump provided landlord property owners with billions of dollars in PPP and economic injury disaster loans to cover their lost rental payments?
Yes, thank you, Congressman. Thank you for your question. Yes, I am aware of that. And regardless of whether or not...
In your opinion, Mr. Griffith, was CARES Act legislation to protect mom and pop landlords by providing them with grants to cover their loss of rental income? Was that a proper use of congressional authority, or was it an assault on the rule of law as you described eviction moratorium as?
Yeah, thank you, and a very important question. Unfortunately, politicians from both political parties throughout the past year have gone beyond what the Constitution prescribes for congressional action. When you look at the aid that was delivered throughout COVID,
and so I don't want to belabor the point. I know that some folks, and you're probably one of them, who just don't believe that government should be there to protect anyone, that it should just be a matter of survival of the fittest and only the strong survive. That Ayn Rand mentality that many of my colleagues on the other side of the aisle espouse. I understand that you probably feel that way, but of course, we're talking about legislation here that's going to protect people from unlawful evictions. And by the way, sir, you do agree that folks should follow the law when I mean, there is a law in place, Mr. Griffith. You do believe that folks should go by the book and not resort to self-help evictions, correct?
Yes, and Congressman, just to be clear, when it comes to my personal beliefs in the proper role of government, there certainly is a role for government to play in assisting people in need. But what we saw over the past year was government action that went far beyond targeted direct aid to individuals.
President Trump signed the legislation himself, right?
That's right. Politicians from both parties at times
come on now, Mr. Griffin.
If you look at
trying to have it both ways. You're trying to have it both ways.
Would you let him answer the question? Let him answer the question.
Well, let me move on, sir. Mr. Shelton, what would you say to those who would say that eviction moratoriums are an unlawful limit on their property rights when you are at the same time offering them money to help get them through the emergency once in a century pandemic that we were all faced with?
Well, let me just say that I would say that we need to bring all government resources to bear. And certainly as we look at what the usual issue is for those who happen to own apartments and so forth, we know that most of the issues that affect them on a daily basis are closer to home. But when we're talking about a pandemic like this, a coronavirus pandemic, in which hundreds of thousands of people have already died and the impact crosses every line, economic, race, ethnicity, gender, and otherwise, then we know that we have to bring to bear the resources from all those places. The money was in place, and there is still resource to help those who own the apartment buildings, and we should help them as well. But allowing individuals and families to be put out of their apartments, to be put out of their rental homes in some cases, I think is outrageous. We have other solutions that we can.
Okay, let me stop you there, and thank you for that answer. Across the country, only 10% of tenants are able to acquire legal representation in eviction proceedings. Professor Ramsey Mason, how will that fact be mitigated by the legislation that our chair has proposed, HR 1451? How will it help in this circumstance?
Thank you, Representative Johnson. It would help specifically in, as I mentioned earlier, the multiple enforcement mechanisms that the legislation contains. This allows, HR 1451 allows not only for an individual who has been affected by an illegal eviction to bring a private cause of action in court on behalf of him or herself, but also for the Attorney General of the United States to bring an action against a landlord who has violated the law. And that is an incredibly important protection for tenants who are not in a position, for whatever reason, to assert their own rights, or in referencing Congressman Raskin's question earlier, if there seems to be a systemic pattern by particular groups of people who are carrying out illegal evictions, the Attorney General is certainly in a better position to address that sort of problem than any individuals would be.
Thank you. I'm out of time. I yield back.
Thank you, Mr. Johnson. Our next congressperson to ask questions will be Ms. Sheila Jackson Lee for 5 minutes.
Thank you very much, Mr. Chairman. It is extremely important to hold this hearing. Thank you to all the witnesses. I'm glad that throughout the testimony that have been given in the question and answer time, the record has already been established that there is a concern, Mr. Griffith, for the mom and pop owners, the retired persons, and the respect for property. I don't think any of us have negated that. I work with a lot of real estate persons who themselves own property, small businesses, and we have the greatest respect for their economic engine as well. But let me try to emphasize what this bill does. We've said it over and over again, and I think it has been carefully crafted, and as it is marked up, your concerns certainly should be readily addressed. But it is to deal with self-help evictions during national emergencies. That is a confined, refined area, and it only represents or acts as a civil rights buffer to the disastrous response that poor people have been able to, unfortunately, have been the victims thereof. So let me, under the CARES Act moratorium, there was certainly more governance. That eviction protection expired on July 24th, 2020. Then came the CDC moratorium, which did not have the firewalls, and that moratorium is currently set to expire on June 30th, 2021. As I was coming up today, I was reading that surges in COVID-19 are now surging in states like Texas because people have randomly put in orders.
Hello.
So that randomly put in orders that would encourage,
so,
unfortunately, the virus surging because of the Delta new variant. So we're not out of the pandemic yet. We don't know how long we're going to be in an emergency. We might need to extend it. So the current eviction under CDC does not protect us against vacating orders, and it permits landlords to charge fees and penalties. Let me just say on the record, and I have to quickly ask this question, despite local, state, and federal prohibitions, the self-help evictions are changing locks, cutting off utilities, refusing to make essential repairs, removing their belongings, harassing tenants in order to create an environment where tenants will leave on their own. In my own district, and Black people are only 13% of the total population, but are 40% of the homeless population in this nation. In addition, Black Americans are far more likely to be evicted. Latinx communities, 26.1% severely monetarily burdened. They too are victims of evictions. So as a story, someone who'd been in a trailer home for 10 years, Miss Christina, I won't put her last name in, they spent 3 months without electricity and water because they had missed just a minor amount of the rent. So let me go to Mr. Shelton. This gives you a right of action, almost like the Voting Rights Act and Section 2, where it happens to you, you can go in and try to get a remedy. Tell me what is so unusual to allow individuals who have had their water turned off, who've been charged fees, who've been given every sort of trap to get you out of there with a family. What is wrong with having the legitimate right to an action, a private action, or the Attorney General having such, when all of the rights have been in property owners, as Mr. Griffith has said? We know what property means. Many things have been property that have certainly been inappropriate in America. Could you give that answer about the validity of that right of action for these people who are most victimized, under your civil rights knowledge?
It is crucial that they have that protection and power as well. Some of the issues that have come up in our discussions just a bit earlier from those who work for legal services now speak to the issue of the expertise that it takes to be able to maneuver through the system in which and way that those rights can be protected. Let me just say, in the long run, I would say that there should be nothing that would prevent that right from being protected. But let me also say, we should make sure there are more resources available for important organizations like Legal Services, as I've worked with them in Eastern Missouri as well as in Boston, Massachusetts, are able to carry out those responsibilities thoroughly.
So your view is that a private right of action does not contravene the Constitution and the Fifth Amendment on the right to property or due process. It does not contravene because there is a court that will make a determination on behalf of the tenant and the landlord. Is that not true?
That is absolutely true.
And their property rights would not be snatched away without that intervening court. And when the federal action from the Attorney General comes, it's not snatched away under this particular legislation. There is a arbiter, which is the court. Is that not right?
That is absolutely true.
Would it be shameful to leave poor people without any action whatsoever, even allowing the legal services corporations to be able to go into court on their behalf?
I believe it would be absolutely unconstitutional.
Thank you so very much. I yield back. Thank you, Mr. Chairman.
You're welcome, Ms. Jackson-Lee. I appreciate each person who's attended this committee meeting, and I appreciate our witnesses. It's been a good hearing, an important hearing for the American public that's been affected by the coronavirus and unfortunately had difficulties with the landlords in maintaining their homes. But that concludes today's hearing.
Chairman, I have some articles, if I might.
Without objection.
I just want to call their names off because they're important articles, if I might, very quickly. One article I'd like to ask unanimous consent to put into the record how Houston area families are being forced from their homes without an eviction notice. It tells the story of Christina Ray, who'd been in a trailer home for 10 years, and the landlord turned off the water and the power in the waning hours of a very hot Houston summer with her and her family. And then HUD, May 18, 2021, growth of homelessness during 2020 was devastating even before the pandemic. I ask unanimous consent to place these articles into the record.
Without objection, it'll be done. And that does conclude today's hearing. And we thank our witnesses again, our Memphis witnesses and our Washington witness and our Miami witness. Thank you for being here and for my tardiness, and we got the hearing concluded. Thank you, members of the committee, and Ms. Ross for sitting in with me. Without objection, all members have 5 legislative days to submit additional written questions for the witness or additional materials for the record. The hearing is adjourned.